Richard Whish, very warm welcome to the Digital Markets Research Hub. It's a pleasure and an honor to have a conversation with you. And you are regarded as the best teacher of competition law in continental part of Europe and in the United Kingdom at least. I know many other jurisdictions follow you obediently, your impactful textbook and your scholarship, and also all your advocacy related to competition law and policy. So we all are learning from you continuously. So I wanted to use this opportunity to ask you not only about the issues related to the specific narrow topic of digital markets and competition law and policy, but maybe we can start with a little bit broader issues, first principle matters. Namely, we live that in rapidly changing, for some cacophonic, for some harmoniously evolving environment where competition law is being interacted with other areas of law and policy, but also is being changing internally very quickly. So how do you see this pretty much established taxonomy of goals? What's the role of consumer welfare, competitive process, and all these things?
Well, Olas, thank you very much for that very kind introduction. I would fiercely dispute that I'm the best teacher of competition law. There are many absolutely wonderful teachers of competition law all over the world, which is a terrific thing. And I've certainly never demanded obedience. I hope that people can understand what I say, but I certainly don't expect them to be obedient. But okay, so you asked me, you begin with the big question. What is the purpose of competition law? What are the goals of competition policy? And yes, I mean, this is a very active debate these days, incredibly active. And I think we can understand why, compared to 100 years ago, compared to 50 years ago, what have we got now? 130 to 140 systems of competition law in the world, in hugely different economies and hugely different cultures, etc. And all of those authorities applying their laws are grappling with the question, what is this all about? You've got thousands, if not hundreds of thousands of practitioners across the world now, the competition lawyers, the economists, etc., who are all debating the very complicated issues that we're confronted with. And there are more competition academics today than there have ever been in the history of the subject. And if you look at the world as it is today, I hate to say it, but I've never known the world to have so many problems as it does have today. And many of them, at least in part, have a competition law edge to them. And we'll talk about digital platforms and sustainability, but pandemics and unexpected wars, I mean, they all kind of have an implication for competition policy. So, of course, there is a very vigorous debate going on. And I'm sure you're thinking, apart from anything, about the rise of the neo-Brandesians and the increasing question as to what the consumer welfare standard is, and so on and so forth. Okay, so we live in very interesting times. But the first thing I would want to say is there was always a debate about the goals of competition policy. If you go back to the beginning of time, which you could say is the Sherman Act of 1890, you could say it's the Constitution of Zeno that had anti-cartel provisions. But whenever there is a competition law, one is bound to ask the question, what is it all about? What is it trying to achieve? And of course, if you go back to 1890, and then, in a sense, even more interesting, I think, was 1914 and the Clayton Act and the Federal Trade Commission Act and the preceding presidential election of 1912. I mean, that election, almost the most important issue in that election was antitrust. And what are we going to do with these trusts? What are we going to do about oil and coal and railroads and whatever? And these were incredibly powerful monopolies that in many ways were causing massive problems of all kinds, not just economic, but social and cultural problems in the United States. And as it were, something had to be done about it. Now, obviously, here we are in 2023, and this is in this incredibly short pace of period of time, these digital platforms have kind of risen out of nowhere to the point where they are now absolutely staggeringly powerful. And obviously, we're going to go on and talk about that in due course. But inevitably, there is a vigorous debate about what role does competition policy have in all of this, and what exactly is it that competition policy should be trying to achieve? Is it just simply about protecting a process of competition, or is there something more? Now, that's quite a lengthy introduction. Second point I would make is, if you look at the United States, what have we had now? 133 years of antitrust policy in the United States. And during that period, the pendulum of intervention and non-intervention has continually been in motion. It's not only now that we're talking about what is the purpose of competition policy. Indeed, why are we talking about a neo-Brandesian school? It can only be because 100 years ago there was a Brandesian school. And what was Brandeis about? He was worried about accumulation of power and the harm that excessive power could do to small businesses. And so we know for a very long period of time, there was a disposition in favor of, if you like, protecting mom and pop, the corner shop, against the big supermarket or whatever it might be. So we've been there before. And then along come the Chicagoans, and they say, "Oh, come on, this is all ridiculous. I mean, this is just simply we're punishing ourselves here. We're punishing our efficient American firms, and other people in Germany and Japan and wherever are getting the benefit." And so the pendulum swings towards the Chicago school, or rather, I should say, the Chicago school swings the pendulum. And has a huge influence, and to the point where in the end you find that the Supreme Court of the United States is predominantly Chicagoan in its thinking, which in simplistic terms could be a way of saying suspicious of intervention and suspicious of enforcement. Well, that's a policy. You know, Brandeis had a policy, the Warren Court had a policy, and then Chicago has a policy. And then since then, people, I mean, before we get to the neo-Brandesians, people start saying, well, hang on a minute, is this Chicago stuff necessarily right? Is it really the case that there's no such thing as leveraging, tying? Can there never be predation? Is this absolutely the case? And so, I mean, as I say, this is just a continual state of flux, and people think and rethink and rethink. Now, if you then talk about neo-Brandesians, whatever that means, if you think about certain evolution emanating predominantly from US universities in the last 10 years, I think this is associated with the perception that certain players in the market just simply have too much power every which way. And this can, of course, include having too much political power because they can buy political parties, and they have too much power when it comes to dealings with employees. Do employees really get a fair share of the benefit of the unimaginable riches that are being earned by some of these companies? Is the manifest inequality of wealth in this world today really something we're happy to live with? Now, these are big, big questions of politics, economics, political economy, etc. But it seems to me inevitable that somewhere we as competition scholars are going to ask ourselves the question, well, does competition law have a role to play in this? And if it does have a role to play, what role? Can it all be accommodated within this expression, consumer welfare? Or is that expression really not fit for purpose? I mean, if we're worried about imbalance of power between employers and employees, or rather owners of businesses and people who aren't even employees any longer because they're on zero hour contracts or have no employment rights, does competition policy have a role to play? Well, I think that there are very interesting questions there. And I think that even within a fairly conventional sort of competition law paradigm, one can see how and why competition law might have a role. And if you then take a more expansionist view of competition policy, maybe it could even have more of a role. I've got many more things I could say, but maybe I should just pause for a moment while you react to some of the things I've said, or move the conversation on.
I would rather use the opportunity and react on a few things which you have said, because you have touched upon few very important avenues where the conversation can evolve. And the first one, probably the most empirical one, concerns this pendulous nature of competition policy. You witnessed, I wouldn't say many, but several significant. I'm talking about this European context. We obviously heard rumor evidence about the change in leadership in DG Comp. So I wanted to connect this with the question, what is the role of personality? Do you think this pendulous driving force is kind of objective, quasi-objective, natural process where the critical mass of the role of personality is rather technical, or this pendulous movement is driven by the vision and proper agenda, ambition, enthusiasm, and commitment to specific policy? How flexible and how dependent EU competition policy, particularly in digital markets, will be on the next leadership, if the next leadership will actually happen?
Yes, well, that's very interesting. That's like, do individuals affect history, or does history throw up individuals? I'll say something about individuals in due course, but I don't think I'm not dodging your question, but I wouldn't want to answer that question purely by reference to the role of individuals, although I think they're very important. I think, so I would go about this in a different way. To begin with, you asked me there about EU competition law and policy, but I always like to think about this in global terms, where you've got 130, 140 systems of competition law. And then competition scholars, it's as though sometimes they're looking for the goal of competition law, as if there's an answer, or that there's I never know whether I mean highest common factor or lowest common denominator, but is there something that unites everything so we can say that's the purpose? And then you just feed numbers into a computer and you get the answer. Well, of course, it's not like that. It's not like that at all. You've got these competition laws all over the world, many of which have been, to a greater or lesser extent, cut and pasted from EU competition law. Not always. Plenty of other models out there, I know that. But these words, abuse of dominance and agreements that restrict competition, they're common words, but they're found in vastly different societies. And when you look at the legislation in question, it's very rare that legislation will ever state what its purpose is. And I bet you that when legislators are legislating, I doubt that they spend much time thinking about what these laws mean or are supposed to mean. It may well be actually that the government is thinking to itself, we've been told that we can't draw down the next tranche of our loan from the Inter-America's Bank until we've done what they told us to do, which is to adopt a competition law. Or else they might have a preamble to the legislation that we want to have competition law because it's going to make everybody happier and it's going to make the world a fairer place and we're all going to smile more. Well, that doesn't really have any meaning. You certainly don't find laws, or there may be one or two sort of suggestions of it that actually would go so far as to say this law is there to ensure that the consumer welfare standard is met. You're never going to find that. Okay, so to begin with, you've got all these laws which, in answering our question, what is it all about? What it is all for? The laws don't give an answer to that question. They're very open-ended. They're very open textured. So the next thing is you have 130, 140 competition authorities. And then depending on the model that's adopted, you might have an authority consisting of 5 or 7 or 13 board members or commissioners or whatever. And then they've got to work out, what are we going to do with this law? Well, it's perfectly plausible that from one, let's say a commission is appointed for 4 years, and then another commission takes over. And then this authority has discretion as to which cases to prosecute. It is inevitable that if you've got 3 or 5 individuals who are the current commissioners that then hand over to another set of commissioners, inevitably they're going to have different views as to how the law should be applied. And of course, it can be more complicated where you have maybe 2 commissioners stand down and a new commissioner goes in. And, you know, how is policy set? It's always going to be in evolution. And of course, in some systems, there's a change of government, and the convention is that all the existing people go and a new bunch of people take over. Well, I mean, how can you have true political independence in a situation like that? You know, so there's so many variables in all of this. And then an additional point I will make is that authorities are swept along by events. You know, in this country, we had a prime minister in the 1960s called Harold Macmillan, and somebody once said to him, you know, what do you think is the most difficult thing you find about being prime minister? And he said, oh, events, dear boy, events, because you never know what's going to happen next. And I think competition policy in the world has been extraordinary in the last, what shall I say, 15 years, to go from a financial meltdown whereby the entire banking system of the world nearly collapsed through a pandemic to the most appalling war on the mainland of Europe. And all of these things affect the economy, including conditions of competition in the economy, and certainly supply chains in a fundamental way. Well, competition authorities have to deal with these things. They also have to deal with the fact that we as a human race are destroying the planet. And actually, that means also, therefore, we are destroying ourselves. Well, how can any competition authority ignore the issue of climate change? Quite what you do about it, well, that's what the authorities, the board members, have to discuss. But oh my God, you know, what an issue that is. And then today you've got, I mean, hopefully it might begin to abate, but the whole problem of inflation. Well, I mean, how can a competition authority really not ask itself, what part can we play in dealing with inflation? Now, you ask about individuals, and I said I didn't want to start answering your question by reference to individuals. Having set all that out, I'm now willing to talk about individuals, because in the end, individual people are going to have to work out solutions to these problems. And I don't think there's the slightest bit of doubt that some individuals have been and are immensely impactful. And don't begin to try to get me to name any individual, because no matter how hard you try, I won't. But I will certainly say that certain individuals have had a massive influence on competition policy, some for good, some perhaps for less good.
Okay, on the last point, without mentioning individuals, you mentioned broader societal policies and interests which in one way or another influence competition policy making, and selection of cases might be one of the directions how you can make these choices, and there are obviously others in terms of adjudicative process itself, or maybe even enforcement decision making. We were driven over the last decades by quite, I would call it, we agreed not to, you broke this agreement, you mentioned immanent. We agreed not to use axiomatic and all this kind of hermeneutic and all other strange words, but so I use it once. Axiomatic competition policy, where somehow we were trying to decode the logic of competition policy from neoclassical economics. And the implication, one of the implications would be that you can have a competition authority insulated from broader societal context, because any political implication would be considered as noise, so to say, as blurring the clarity of our mathematical calculations and measuring welfare. It was an illusion, or maybe not, but it can be seen as a workable hypothesis. Now we understand that this is that competition policy means many things for different people, etc. But we still pursue this vision that competition authorities, when we talk about the UK, when we're not talking about the Commission, but about the UK, for example, should be isolated from the government. So my question is, do we have to establish different channel of communication? How should the competition enforcer be mindful of broader societal context? Should it be somehow formally communicated to their competition policy agenda, or it's something which they have to decode from just watching the news and being kind of Dworkinian, reasonable, prudent person, mindful, responsible, and just taking this context implicitly and somehow making their policy making in this more softer, less visible, less tangible fashion?
Well, I would start by saying, as I've said before, it does actually depend upon the relevant law, because competition law, competition institutions can be set up very differently across the world. I mean, ultimately, obviously, any competition authority is going to have to do what its legislation tells it to do. And so if in South Africa, the Competition Commission is looking at a merger and it asks itself whether this merger could be harmful to or beneficial to historically disadvantaged people, it does that not because it's sitting there thinking we're worried about historically disadvantaged people. It's doing it because the legislation tells it it has to do it. That's in the law. And it's absolutely South Africa's right to put that in its law. And it's outrageous if people from other jurisdictions start saying this law is a silly law because that's nothing to do with the technical analysis of markets. Well, tough. If the legislation says it's got to be done, it's got to be done. So that's the first point I would make. You've simply got to look at the law. And then you've got to ask the question, how is the authority set up? What does the legislation say about it? Does it say that it has to set out an annual plan? And does that annual plan have to be submitted to stakeholders? And are you ultimately responsible to Parliament for explaining whether you have delivered on the plan? And are there agreements with the Finance Ministry as to the, I don't know, the number of decisions that you'll publish in a year, adopt in a year? You know, there's no one size fits all. There's lots and lots of different models around the world. And of course, competition authorities will do what they are told to do. But insofar as you have an independent authority, where very probably the legislation is drafted specifically in order to ensure that it's independent, then it will have to form its own policy within the law. So, for example, does it have a discretion as to which cases it takes? Or, under that relevant law, is it required to react to every complaint that it receives? There's a big difference in itself. Now, actually, in Europe, the General Court decided in Automec number 2 against the Commission that actually the Commission did have a discretion to set its own priorities. But that was in 1991, I think. You know, that's what is that? 29 years after Regulation 1762. Took 29 years to work out whether the Commission could effectively set its own policy. The CMA in the UK undoubtedly does, albeit it's given steers by government and so on and so forth. So then you're asking the question, how does the authority decide what it's going to do? Does it watch Google News and make up its mind? Well, I mean, obviously, you're going to have an authority and it is going to decide, it's going to discuss how it should set its priorities. And you can look at the CMA in this country, and they do publish an annual plan, and they do say that maybe we're very worried about disempowered consumers, or we're worried about imbalance in labor relations, and this is going to feature in our decision making. They have, for a number of years, said we are, what should I say, interested in digital markets because of the incredible rise of power there. So obviously these are hopefully intelligent, informed people who understand the zeitgeist, know that they've got limited resources, and have got to say, okay, what are we going to do next year? And they are accountable, and they are transparent about it, and so on. However, you're also talking about, can you, as it were, reduce competition policy to some sort of technical exercise in analysis of markets, etc. And so you define what you mean by consumer welfare, and you say, well, consumer welfare means, is it going to lead to increased prices for consumers? And those are the cases we're going to do. Well, I mean, if and when you come to the technical analysis of markets, I think that is a scientific exercise. I think once you've decided we're taking this merger to phase 2, and we're going to ask, is this going to substantially lessen competition, or is this going to create a significant impediment to effective competition? Now you're doing it for real. Now you're at the coalface. Well, that is a technical exercise. And it is nowadays amazingly sophisticated. And that's where the economists and the econometricians and the accountants and all sorts of other people have come into the subject and do very, very important work. So that is technical. But that doesn't mean that you only do technical stuff. I ought to say, just while it's in my mind, by the way, consumer welfare. I don't mind people talking about consumer welfare as long as they don't define it. I think consumer welfare becomes a problem when you start trying to define what it means. I am perfectly happy with the idea that competition policy is concerned with consumer welfare if that means the welfare of consumers. And so when we go to work and do our stuff, we want markets to work well for consumers. I'm happy with that, and I don't mind calling that consumer welfare. Some other people might use the expression to mean, unless you can prove that the price of widgets is going to go up by 10%, there's no competition infringement. Well, those people have got, they've got a goal. And actually, I think it's to have as little competition enforcement as possible. So if that's what's meant by consumer welfare, I'm not very happy with it. But if it's used in this kind of very general sense, I think it's quite helpful. Competition policy is there for the benefit of consumers.
And I cannot not ask you this follow-on question on technicalization. We see many people saying that in the past the grass was greener and you would have a complicated, potentially complicated merger case with in a thin folder, and all the documentation would suffice to scrutinize this complex case, potentially complex. Now we are talking about of physical and digital volumes, many thousand pages, and it goes on and going on, and increasing costs, obviously, and time, and obviously given opportunity to the strongest to invest in the brightest economic and legal minds, and to decode the legal juristic glossas in the most creative but obviously reliable fashion. Another camp say, well, if the billions are at stake and due process must be observed and the technicalities matter, and obviously the truth depends on context, and you probably answered this question already. You shouldn't caricaturize both camps and take it up kind of absolutist position, but maybe you can reflect on the kind of nostalgic. Are these nostalgic resentiments, or it's there is we went too far with technicalization of the discipline?
Well, look, one of the things that I find frustrating nowadays is that I said at the outset, we've got 130, 140 authorities. We've got tens of thousands, if not hundreds of thousands of practitioners, academics, whatever. And somehow it seems to me that people are succeeding in making this subject more and more complicated, forever more complicated. And forever more data and forever more arguments and so on and so forth. And one hears about these ridiculous documents of thousands of pages and hundreds of annexes and so on and so forth. And sometimes we hear about costs claims that have been made, and we sometimes begin to see how much money is being spent on legal services, economic consultancy, corporate relations, etc. Well, I know I'm being recorded, but I'll say it. I think the whole thing is absolutely ridiculous in the extreme, and that it's all got out of hand. And I think that there are powerful domcos, dominant firms, and big cartelists who have an interest in making it as complicated as possible. Dare I even suggest that the lawyers and the economists might benefit from this complexity? It's just conceivable, isn't it? Well, okay, that's how the world is. So what's the answer to it? And it seems to me that what's gone missing in all of this is common sense, and that there needs to be more common sense. And I think here this varies from system to system and the institutional regime. But where you have, say, the European Commission review by the General Court, or in the UK, the Competition and Markets Authority review by the Competition Appeal Tribunal, we know that the parties, some parties, are going to make it as complicated as possible and obfuscate and delay and overwhelm authorities with a vast amount of information. We know that's going to happen. It's very difficult to stop that happening. But then there's the appeal leg. And it seems to me, frankly, that judges have an enormous responsibility here to try to keep the system under control and to not allow some of these more, to my mind, egregious things to take place. Now, it's a vast subject. How do we bring this about? Is it personnel? Is it procedures? What is it? But when I say about people making it all more complex than it really is, I honestly do think at some level that what we're trying to achieve here is not really that difficult. We're trying to stop people colluding in markets, and we're trying to stop dominant firms from excluding their competitors unfairly, said in a very colloquial sense for these purposes. And in some circumstances, we're trying to stop monopolists ripping people off. This isn't really that complicated, is it? I think there are more complicated laws in this world than that. And I think when a competition authority is running a case, it should, if there's a good case, I think it should be possible to look an appeal court in the face and tell a story that is hopefully convincing. The reason why we did this case is that we think that they were taking deliberate acts, for example, to exclude a competitor, and that competitor was a perfectly good competitor. And this is our story. And if it takes 1,000 pages and 100 appendices to tell that story, then I think it's not a very good story. So I think the authority has to be able to tell a good, clear story. And I think a defendant has to be able to explain why that story is not a good story in less than 1,000 pages and 100 appendices. And if it can't, then I think the court has to say, go away. Now, I think maybe there are practical things that can be done in terms of limiting pleadings and having a limit on the length of documents, and maybe insisting, the narrative has got to be of a certain length. If there has to be whizzy, clever econometrics, well, maybe that does go into appendices. But surely it must be possible to tell the story and or rebut the story in a way in which an ordinary intelligent person in the street can understand. So I think there's a huge job of work to be done here. Well, it's a big subject. I can't begin to go into it now.
Last question on this, and then we move to digital markets. Obviously, the technicalization, the technicality of the increased technicality concerns mainly the defense side. But you mentioned that damages claims are absolutely everywhere as well. And so this is the game you need two players, so to say. We see the same or similar trend in trying, absolutize and to instrumentalize all possible ways for damages claims. Is it, on one hand, it obviously is the private interest is doing the job for the greater good of society, one might say, and that's what we were gonna consider it at the beginning of this private enforcement era, of popularization of private enforcement era in the European Union. On the other side, some people say that it went a little bit too far, and there are some issues which are a little bit excessive. How do you see it? Again, it's like 50-50 or it's 70-30?
Well, I mean, the first thing I would say is that I think the availability to people who have been harmed of damages is not only good for those people, but I think it is also good in terms of deterrence. And I would imagine, I do not know, I do not have clients, but I would imagine if I was a truck manufacturer thinking about entering into a cartel for the next 14 years, and if I were to look back at history, I think probably I'd be more worried about the impact of the damages claims against me than the fines to which I have been subject. I think that case demonstrates that this is highly significant. And so in that sense, I think the availability of damages is a very important part of the enforcement machinery of competition law. When it comes to proving the effects, etc., has it gone too far? Well, how can it have gone too far? I mean, this is down to the courts. It's the court that has to be persuaded that a claimant has suffered harm as a result of that cartel or that unilateral behavior. It's not going to award damages if it's not satisfied that there's been harm. So in that sense, how can it go too far? I can see that you might want to be very careful about collective claims and whether the collective regime has come out quite in the right place, and are too many people being incentivized to bring too many cases, by which I mean lawyers and funders and whatever. I mean, that's a different issue. But it's for the court ultimately to decide whether economic harm has been caused, and that is a factual issue. Incidentally, showing that even object cases, the effects of object infringements are relevant because the effects are the damages claim. But then it comes to the question of, are maybe economists being a bit too fanciful in their defenses by doing the whole kind of, well, of course, on the one hand and on the other hand and on the other hand and on the other hand. And I have been rather fascinated in watching some of the damages judgments in recent times, where it seems to me that the courts in the UK on a few occasions now have said there was harm, and we reject these economic theories as to why there was not harm. I hate to repeat it, but I think there's quite a bit of common sense in all of this. And so again, I think this is down to the judges to sort of run the case sensibly and to be dismissive of the more fanciful theoretical arguments that are sometimes advanced. But you can read some of our judgments and see that arguments that were too theoretical have been rejected, both in our CAT and in our High Court.
Okay, let us move then to digital markets. And we know that at least conventional wisdom, or a very popular narrative, explains to us that one of the incentives for adopting the DMA and the MCC was this procedural, an attempt to make procedural shortcuts and to make the process more enforcement friendly and quicker, and granting bigger discretion to deal with systemic issues, which would not be dependent on identifying instance of infringement in the first place, but rather to identify systemic market failure, whatever the terminology might be. So we see two sister regimes adopting pretty much simultaneously two laws, where the motivation is pretty much, we've been cross-fertilized continuously, and we see the objectives of these goals, political, pretty much identically. But technicalities matter, of course, and we see that DMA and DMCC are very different in terms of the formulas which are being used. And is it too early to say which model would be more effective and would deliver on these expectations? Will it doom to deliver, or we invest too much with our expectations, thinking that everything will be turned once the new rules will be adopted? And maybe the third part of the question, is it better to start from scratch as a DMA, picking up the contestability and fairness as kind of, yes, the legacy is competition law, ex post competition law, but it's a new start. We start with carte blanche, or rather as a continuation, as appears to be in the bill in the UK?
Well, that appeared to me to be about 7 different questions, so I barely know where to start. Let's start with the DMA. Is the DMA justifiable? Well, to my mind, 100% yes. And it goes back to what I said earlier. You know, the power of the platforms, the power of some platforms is immense. And I don't just mean market power, I mean power generally. And when you've got more money stashed away in a bank in the Cayman Islands than the entire continent of Africa possesses, you're bound to ask yourself, is this really quite healthy? And then you look at the competition problems that have arisen in these terribly difficult cases involving the GAFA companies. And, gradually they're going through the system, and the commission is having some successes, and but there are plenty more appeals to come. We'll see where it all ends up. But I honestly do think that the competition approach to this is just simply too slow. It's a statement of the absolute obvious. I think the complaint in Google Shopping originally was in 2009. And we're now waiting for the appeal to the Court of Justice, which will not come until 2024. 15 years. There is a phenomenon known as tipping. Markets do tip. And so I just think it is too slow. And one of the reasons it's too slow is market definition, market power. And, we don't know what the products are going to be tomorrow. We know there are going to be products that now, today, we can't even begin to envisage. We don't really know what this metaverse is. We don't understand AI, etc., etc. And yet, firms might be doing things and making acquisitions and spreading their tentacles and leveraging or whatever into markets that we can't define, because nobody, probably even some of the people inventing and doing the engineering, don't actually know what it is that they're producing. And then you have to define a relevant market, because Continental Can and the Commission in 1973 says so. Come on. And then market power. Is it market shares? Of course it's not market shares. So one of the things it seems to me the DMA does is to take 2 years out of an investigation of determining the market and the market power. That's just leave that out. And then you come to the theories of harm and the abuses. And it's obvious that many of these cases, you can see how there might be an abuse by analogy to something that happened in commercial solvents or whatever, or the telemarketing judgment. But, really, we know that we're dealing with something new and different. And then you've got problems of remedies and blah, blah, blah. So I think that it is reasonable to say we are so worried about this sector that we think that some ex-ante regulation is justifiable. And people seem to me to forget, when they're discussing the Digital Markets Act, do we remember the Electronic Communications Framework Directive? What was that? That was ex-ante regulation because of the problem of market failure. There's nothing new in this, actually. So I think the DMA is a perfectly reasonable reaction to it all. We can argue till the cows come home about whether the obligations in Articles 5 and 6 are the right obligations, and do they need to be added to, subtracted from, tweaked? Well, I'm sure they do, and they will. There's a market investigation system for taking things out and putting new things in, etc. Manifestly, there is no economic efficiency defense in Articles 5 and 6. Well, frankly, I think that is because of the problem I was discussing earlier. The moment you start having economic efficiency defenses, then let's have another 1,000 pages. Let's have another 100 appendices. I mean, as I see it, this is a perfectly conscious choice, and many people hate it and will hate me for saying that I think it's reasonable, because I think it's necessary in the circumstances. So I believe in the DMA. Now, I'm reluctant to say anything about the DMCC, because let's wait and see. Let's wait and see if this thing gets through Parliament. I wouldn't be surprised to find that a general election has just been called for the autumn. Anything can happen. But let's face it, I mean, the DMA and the DMCC as it exists at the moment, they're not siblings, but they are first cousins. A different point, Ullis, going back to what you were saying, is I don't see the DMA as being competition law. I think the DMA is a piece of legislation with its own recitals, its own motivation, its own legal basis. and its own list of obligations. And manifestly, some of them have grown out of competition law, others have grown out of business to business protection laws or consumer protection laws. It's well, again, it's a cousin. It's not a sibling. And we've just got to accept, we've got our 101, 102 hats. Well, let's wear them when it's right to do so. But this legislation has to be read according to its own terms. And I've heard you say that it gives vast discretion, etc. And I was just looking at I got it here. I never go anywhere without my DMA these days. And I look at Articles 5 and 6. They seem to me to be perfectly meaningful. Discretion, well, I think there's quite a lot of discretion in saying to the Commission or the court, you can decide whether there's been an abuse of a dominant position. That seems to be a little bit more discretionary, or shall we say, to give more of a margin of appreciation than these obligations in Articles 5 and 6. So I don't find anything sort of wacky or vastly different from other legislation here.
Let me move then my focus on one part of the DMCC, which is it's incomparably softer discussion in the UK when we look at the DMA and DMCC. But one issue is being articulated by many and different stakeholders: full merits review or judicial review. With your experience, and I wanted to combine it with another question: how much of these provisions, DMA and DMCC, will be justiciable? How keen the parties who are capable, definitely capable, to problematize any word or any norm or any article or section, depending on which law we look, how much litigation will we get, and what are the most problematic elements in these bills? Do you think we will end up in a few years' time with this in this endless ping pong of problematizing the most innocent sleeping provision in one of these two acts? Or because we are talking about participatory competition policy, the gatekeepers or SMSs will agree that it's time to be more cooperative and try to find meaningful operational solutions to these systemic challenges?
Well, I can't possibly comment on whether people are going to be cooperative or not. I mean, we've simply got to wait and see. I think I have noted, perhaps it is true to say, that some of the platforms perhaps are more inclined to have discussions with authorities than others. And that's just a rough and ready impression that I have, but let's wait and see. Will there be litigation under the DMA? Well, will the sun go on rising and setting? There will be vast amounts of litigation, no doubt about it whatsoever. People are hugely incentivized to litigate. Well, I won't start mentioning recent cases, but we can see the kind of things that will be litigated. So I think it is absolutely inevitable. I'm reluctant to go into the DMCC full merits appeal. I mean, that's a big issue, and because it's relevant to market investigations and mergers and the regulatory system. I think it's too big an issue to take on now. But will there be litigation? Yes, there will. I think what is very interesting in all of this is the sense that the platforms, might they, because they have to comply with the DMA, might they roll out their DMA compliance regionally or even globally? Because if you have reconfigured, if you re-engineered things for the purposes of the EU, are you then going to have something different in Papua New Guinea because their law is different? I think it's a terribly interesting thing. This goes back to the Brussels effect. I think it's a very interesting thing. When the CMA investigated the Google privacy sandbox, I see that when they reached commitments with the CMA, Google then said, and we will pursue this policy globally, not just in the UK. I think that's a terribly interesting effect, actually, of these pieces of legislation.
I think they also did it with French competition authority a year or two.
Yeah. I think it's a Japanese case as well that had a similar effect.
I know we are approaching the end of the hour, and we usually try to close the conversation with asking the guest to provide recommendations for students. But I wanted to use this opportunity and to ask for your recommendations also to academics. Maybe you've been at King's College London for many years. I know that you mainly you were focused on postgraduate degrees. Maybe you can give some tips. We at Newcastle have our LLM in competition and digital economy, how to follow the suit, what are the main challenges in this regard, but also broader in the UK academia, you witnesses some changes, metamorphoses, are they positive? Maybe there are some shortcomings. How do you see these processes going?
Well, those are two very different things. I mean, there's the constituency of students. I'll come back to that in a moment. But UK academia generally, gosh, well, that's a big subject, isn't it? I ceased to be a full-time academic 10 years ago. And even when I was in full-time academia, I dealt only with PhD students and LLMs. I last taught an undergraduate student in the 20th century. So that's my way of saying that I was never as involved in the workings of the academic system generally as many other people. I am hugely anxious about the state of academia in the United Kingdom and the way in which things have gone, and the introduction of fees and the idea that some competition was going to be introduced between universities as to what service they offered and the fees that they charged. And of course, what sometimes happens in life is that the maximum is 9,000, and so everybody charges 9,000 and there's no competition whatsoever. In other words, the existence of the policy of having school fees capped acts in a cartel-like manner to achieve a situation where everyone charges the same price in circumstances where they can't increase those fees to home students because the government won't allow it because of the inflation agenda. And so the universities become more dependent on overseas students. And in the world of today, those overseas students at a moment in time, hundreds of thousands of students might disappear from the system. And I hate to think that where that leaves the universities. So, I mean, this is a massive subject, way beyond the scope of what we're talking about today. But if you ask me as a citizen of the United Kingdom, I'm deeply concerned about the state of the universities. I think it's profoundly unhealthy. Students studying competition law and policy today, well, do it because it's fascinating, whether your interest is in law itself, law and institutions, but hopefully as young people going into the world, looking at politics, economics, political economy, I think this subject kind of has it all. Quite frankly, I think it is absolutely fascinating. And there's a new subject area opens up almost every day. At my age, I don't think I've ever found competition policy as interesting as I find it today. I think it's terrific. So my advice to my students in the days when I was teaching was, in order to understand this subject, please read The Economist each week and the Financial Times every day, because you have got to just have that feel for what's going on. What are markets all about? How is the finance raised? Where is the action in relation to particular sectors now? Is everything moving to from the west to the east? All of these things are dealt with in a quotidian basis in The Economist and the Financial Times, plenty of other places as well. But these are almost publications of record. And I find it absolutely fascinating that there's rarely an edition of The Economist or the Financial Times that doesn't have some discussion of competition law and policy and actual cases. And so for students who want to be able to relate what they're studying to the world around them, frankly, I can hardly think of a better subject than competition law, quite frankly. You can study incompletely constituted trusts in your trust course in the second year, but I don't think you're going to read much about it in the Financial Times or hear about it on the news. Competition law is just there all the time. So get this feel for the business world, understand what it is. Even if you don't like it, you've got to understand what it is.
Richard Whish, thank you very much for this illuminating conversation.
Pleasure.